Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha. I head up brand awareness at Reveal. On each episode of each eDiscovery Leaders Live, I get the chance to chat with luminaries in eDiscovery and related areas. Today it's going to be a focus more on related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. Our guest today is Ken Callander. Ken is the founder of Value Strategies. Ken, welcome.
Hey, George, how are you today?
Wonderful, and glad to have you join us. I would like to start, as I usually do on these things, with having you tell us a bit about your background and what it is you do today.
Sure. So I started off with almost 30 years at Hewlett-Packard. I started off there in operations and manufacturing, ended up in pricing, business development, and marketing of professional services for HP. In 1999, we split the company between HP and Agilent Technologies, and I went over to Agilent as head of corporate marketing for them, basically handling the pricing, marketing, business development of all our products at Agilent. I was there for another 6 years and decided to get out of the high-tech world, and I went into some consulting around professional services, marketing, and pricing, and helping professional services businesses. And I was doing work for insurance companies and architectural firms and accounting firms, and I started to do some work for some law firms. I'm not an attorney, I'm a business guy. And one of the big international firms I did some projects for asked me to come in and build out their entire marketing team. And I ended up becoming the CMO of a large international firm. And I was there for about 6 or 7 years, helping them manage the pricing and marketing of their services. And that's sort of where I learned the legal industry. After 6 or 7 years of law firm, I decided to go back to the corporate side. And I ended up going in-house at Uber as the head of legal operations and chief of staff to the general counsel. This was back in 2014. And back then, that's when Travis Kalanick was running the place, and the place was wild and crazy, and just to put it mildly. And we had very few people in the legal department, but it was very, very busy. And our general counsel was very busy just dealing with a lot of board work, so she passed a lot of this work of running the department to me. And about 6 months into it, I went to her and I said, Sally, we're spending way too much on outside counsel. I said, if you really want to be innovative and creative, let's try moving off hourly rates onto value-based fee arrangements. And she said, well, what's that? And I said, actually, value-based fee arrangements have been around for decades. We used them back in the 90s in HP for professional services, but I've never really seen them used in legal services. And so I convinced her to try it out, and we started with corporate and M&A. And over the next year and a half, we moved Uber completely off hourly rates across the board. Everything from litigation to corporate to IP to employment, privacy was all off of hourly rates. And we found it was saving us about $4 to $5 million a month in outside counsel spend. So it was a huge success, and I was there at Uber for about 3 years. And this is sort of my testing space where I tried out different ways of doing this. And I decided to leave and go back to the consulting world and work with companies in that space of really helping them better manage their legal spend, especially around outside counsel spend management. And so since then, I've now been working with mostly mid to large size companies, helping them move off hourly rates onto more value-based fee arrangements so that they can get the predictability they need. Because nowadays, most general counsels and CLOs, they're like any other manager in the business. They've got to hold to a budget, and more so than they've had to in the past. And so this is becoming more and more of value to them, to be able to have predictability in their spend budgets, especially with outside counsel. So being able to have that predictability significantly reduce spend with outside counsel. And by moving off to value-based fee arrangements, the savings are between 20 and 50% of your outside counsel spend, which is a huge amount when you're spending, tens or even hundreds of millions of dollars on outside counsel. And then lastly, it reduces your administrative costs because, instead of spending a huge amount of time just reviewing outside counsel invoices, when you move things to fixed fees, all of that goes away. When I was at Uber, we actually did a spend analysis and found that 17% of our attorney time was being spent just reviewing outside counsel invoices. So when the attorneys didn't have to do that anymore because we had moved off hourly rates, we basically got a 17% virtual headcount increase in the department, which was a huge difference. And so all of those reasons, it really benefits my clients, and they love the idea. And a lot of clients now, with some of these outside counsel rates hitting over $2,000 an hour, the GCs and CLOs say, where does this end, right? At $5,000 an hour or at $10,000, where does it get to be ridiculous? And they already think, and they're just looking for a different way of pricing services instead of the standard hourly rate, because hours don't equal value. They don't equal results. It can take one attorney 2 hours to do something, take another attorney 5 hours to do the same thing. So instead, the idea of value-based pricing is looking at not only the value of the matter, but also pricing it based on tasks, activities, and deliverables and results, instead of how many hours did it take you to do something.
I have so many questions for you. Far more questions than we will have to cover today.
Okay.
Before I get into those, I just want to note that this issue, as you said, it's been around for a long time, and it's been around for a long time in legal circles as well. One of the very first American Bar Association meetings I went to, this would have been most likely in the late 1980s, had as a topic of discussion value-based billing and the death of the billable hour.
The death of the billable hour. I've been hearing that for decades.
And here we are still.
Yep.
That topic would come up on a regular basis at what used to be the ABA Litigation Section's Committee on Corporate Counsel annual meeting, where there was a time set aside on Sunday mornings. This was a weekend-long, Thursday through Sunday meeting. There was time set aside Sunday mornings for inside and outside attorneys to talk with each other. Every year, this came up as a topic. Every year, the in-house lawyers said, we want value-based billing. Every year, the outside lawyers said, you mean you just want to pay us less? Is that dynamic still the same?
I think there's a lot of reasons why it hasn't gone away, and I don't really expect it ever to go completely away. But as you're starting to see now, especially with the onset of ALSPs that have come into the market and starting to take a lot of the lower commodity level work and starting to eat into that from the bottom, and the firms are having to move up and up in the value chain in terms of what they provide in terms of services. You're seeing more and more that these services are being eaten away and moving to other types of fee arrangements. So even in the e-discovery space, right, you've got prices per gigabyte or a fixed fee. And in patent prosecution, you're seeing fixed fees for a utility patent, for an interference, for whatever. And you're starting to see that like fixed fees for an EEOC charge. And so they're starting to move up that way, and people are getting used to that. But part of the problem and the reason that it hasn't gone away is that what I find is most in-house attorneys have a difficult time understanding what the value is of the services being provided. And so they often will go to their firms and say, give us an alternative fee arrangement for this work. And the law firm will give them something, still often tied to hours with a collar or something else, but they'll give them some sort of alternative fee arrangement. And the in-house team doesn't know how to evaluate whether or not that's a good deal for them. And they just assume that if the law firm provided it, it's probably good for the firm and not for them. And so they just come back and they say, well, we're not too sure if that's going to work for us, so just give us a bigger discount. And they go back to that, because you have to understand that, all the lawyers out there, whether they're in-house or in the law firms, all grew up with a billable hour. And that's all they know. And to do something completely different and look at pricing things different and valuing things different is really hard for them to get their head around that. And again, the other thing you run into with the in-house team is they are completely stretched, right? Most teams run really lean, and they're limited in their head count, and everybody's got 17 things they're trying to do, and to try and take something else on is just more than they can deal with. So they just say, okay, that's really interesting, but just give me a bigger discount. And so that's what you go back, and you hear from the firms all the time, hey, we offer AFAs, but then they just always go back to hourly rates. And that's the reason why that I find is they just have a tough time trying to evaluate whether this is good for them or not, or what the value of that particular matter is.
I'm hearing lots of problems. What are some palatable solutions, palatable both for the corporations and their in-house lawyers and for the law firms?
In thinking of things in terms of value, the problems with hourly rates, everyone knows, is it doesn't incentivize the firms to be efficient, right? And in fact, you can argue that it actually incentivizes them to be inefficient, because obviously the more hours they bill, the more money they make. Now they're, not against the firms. They are trying to do a good job for their clients, but that's how they make revenue, is by billing hours. So, and the in-house people know this. They know that it's an inefficient way to doing that. So thinking about better ways to be efficient. And from the other side, if you have an attorney, a law firm attorney that charges $1,000 an hour, and in a 30-minute phone call with a client, they save that client $15 million. What do they get paid for saving the client $15 million? $500. Okay. So again, you're not equating the value, what you're being paid to the value being provided, right? So it works both ways. And, and law firm economics is really interesting in the sense that law firms is really one of the only businesses out there, industries out there, that actually limits the amount of revenue that they can gain, right? I mean, what other business actually puts a cap on revenue? And law firms actually do that, because if they got 100% utilization and 100% realization, in other words, they met their quotas for all their attorneys, everyone got 100% or better, and they all got 100% realization, meaning they got, for every dollar they charge, they get the dollar. That's the maximum revenue they can get. Whereas if they started thinking about pricing for value, hey, we can save you this amount of money by doing this, or this is worth this amount of savings, we'll charge you X for that, what percentage of that savings. It's a whole different way of thinking about it, where they could actually make a premium on what they're doing instead of just billing by the hour. And if you think about other professional services businesses out there, or industries, think of the accounting. Think of the Big Four, right? Or you think about management consulting, the McKinseys or the Bains of the world. They got off hourly rates decades ago, back in the 90s. They don't bill by hourly rates anymore. They moved it to where all their partners and associates get paid a salary, and then they get a bonus at the end. But the law firms have a tough time switching to that, because their model based on hourly bills goes so far back, and it's so entrenched that trying to change compensation is like the third rail of law firm politics. You don't touch it, right? So it's a really difficult thing for them to make a difference.
And yet we need to touch it. So how do we touch it and not kill ourselves?
Well, what's happening, I think, now is a lot of larger companies, and ones that I work with, are starting to push the firms into predictable pricing models, right? Which typically tend to be fixed fees and success fees and things like that are not tied to hourly rates or hours billed, and instead tied to deliverables, right? And that's forcing the firms to come up with figuring out, how do we do this within their current comp models, which is still based on hourly billings. So I think eventually these firms are going to have to realize that the way to do that, and if you look at some new firms that are starting up, they figured this out and they're moving to that salary model, right, and trying to get away. And there are some firms now that don't bill on hourly rates anymore. They do bill on deliverables, just the same as, the contractor that does your kitchen, right? And it's $50,000 to completely remodel your kitchen. You're not paying time and materials anymore for that. They're giving you a price for a deliverable, right? Or when you buy a BMW or a Mercedes or a car, you pay a certain amount. You're willing to pay the $40,000 or $50,000 for a car these days. You're willing to pay that because you think it's worth the quality and the performance and the styling and everything. You're willing to pay the $40,000 or $50,000 for that car, but you don't go up to the sales guy and say, well, how many hours did it take to build this car, right? No, because and that's where the in-house teams and the law firms have to start thinking about, what's the value of the work we're providing. There's a lot of times I come into clients and they've got a $100,000 litigation on a contract breach where they're being sued for $100,000, and when they give it to one of their attorneys or their outside counsel, and they realize when they've settled it, that they've spent $500,000 dealing with this matter that they could have, that was worth only $100,000. So why, that doesn't make sense. They should have just settled, just paid the 100, and they would have been way off ahead of it. So it's really thinking about, what's the value of the matter. And then you look at, and value-based pricing is based on the economic value of the matter, which is broken into the actual economic value, the perceived value, because if you're let's say you have a contract breach litigation and you're being sued for $10 million. Okay. What's the total risk in that matter? $10 million. Okay. So then you take that, then you say, I go to my clients and say, what's the perceived risk? In other words, I go to my clients and say, if you lost this case, would you really pay 10 million? Oh, no. What do you really think, your risk here? Oh, it's maybe 3 or 4 million. Okay, good to know. And what's the strategic value? In other words, if you lost this matter, lost this case, what would be the financial impact to the corporation, the risk to the brand value of the litigation, to the corporation, and or future litigation, right? If you lose a class action in California, you might get hit with a class action somewhere else, right? So that could change that actual value. Then you look at, when you think about the value price for a particular matter, it's that price of the matter, the value of the matter, estimated value of the matter, the jurisdiction that you're doing it in. Is more expensive to take care of something in New York than in Omaha, right? The type of firm you want to use, do you want to use a AmLaw 20 firm, or are you willing, for a lower price matter to use an AmLaw 200 firm? Okay. And then thinking about sharing the risk with the firm, putting in pricing models that will help share that risk with the firm so that they have some skin in the game, right? It's not just the risk only on you, but they're willing to share some of that risk. So that all goes into figuring out what that is. I know that's a lot to take in all at once.
Well, one of the challenges for law firms is that, unlike a manufacturer, unlike a contractor remodeling the kitchen, you have an adversary. And your adversary it's your adversary. If your adversary knows that you've got some limits on how much revenue you are going to get, it is to their advantage to push you to a place where you need to put in more actual time. Because if you've got a fixed amount you're going to receive, we'll simplify this. You get a fixed amount you're going to receive. Every additional hour you put in reduces your profit.
Yes, so you're talking about litigation, right? So you're talking about litigation in particular because that's where you have an adversary, right? You know, or it can be in a transaction case too.
Right, less so in a transaction because in theory you're both working toward a common goal, but certainly any dispute resolution.
Yeah. So when it comes to, for example, litigation, you were looking at a fixed fee by phase. So it's like a fixed fee for motion to compel arbitration, or a fixed fee for a motion to dismiss, right? A fixed fee per deposition, you know, per discovery motion, per expert, that way, because you don't know up front how many depots you're going to do in a matter. You don't know what's going to happen. And yes, you know, if perchance your adversary, you know, on the counterparty knew that you were on a fixed fee structure, could they take advantage of that? Possibly. But the other thing I tell my clients is that you have to be fair to your firms. And if things don't go, if you're doing a motion to dismiss, you know, and you have a change of venue, or you have something that happens that nobody really expected, go back to the contractor doing your kitchen, right? You know, you tear out the wall and it's full of dry rot and nobody knew that, it's going to cost you more, right? And you're going to go back to the contractor and say, well, we need to replace this wall. How much? Well, that's going to be another $5,000. Okay. Okay, good. The same thing happens in litigation, right? There's a set of assumptions that are based for each phase, and you have a fixed fee for each of those phases that you work towards. If you go outside of those assumptions, you need to be fair to your firms and adjust that price because you do outside. Now, on other types of matters, no, not litigation, when you're just doing project work, if you're asking for, you know, a 50-state survey of financial regulatory requirements in all 50 states, you know, there's a set of deliverables, you know, task activities, deliverables there, a timeline needs to be done. The firm should be able to figure out how much is that going to cost, you know, and be able to give a price to the client on a fixed fee to do that work, right? So not everything is litigation, but that would be done. And same on M&A, you know, on transactions, it's still a fixed fee by phase. So on an M&A, it would be a fixed fee for initial term sheet, initial due diligence, deep dive due diligence, negotiation, close, post-close, documents, et cetera, right? So, and again, those are a fixed fee for each of those phases.
When it comes to value-based billing, what sort of adoption rates are you seeing, both on the corporate side and on the law firm side? I mean, how much are people actually using this approach?
You know, well, obviously I see it a lot because my clients are the ones that want to do it. I tend to find that, you know, it's a lot more, the companies that are adopting it are the ones that tend to be a little more innovative, right? You get sort of the old school, and I have had old school clients, you know, that want to go this direction, but the ones that have been around a long time tend to have an older in-house constituency of attorneys, right? They're older, they have longer term relationships, you know, with their firms. They don't tend to be quite as innovative. Their leadership is sort of old school. They, you know, are not really the ones that are moving this direction. But you know, the tech companies, younger companies, faster moving companies tend to be more innovative throughout the organization and push innovation. They're the ones that tend to do this. It's not completely that way because I've worked with, you know, large conglomerates that have been around a long time that have realized that they need to move this direction. But, you know, in general, I'd say it's some more innovative companies that are going this direction.
To what extent have you seen this value-based approach used successfully with respect to e-discovery costs?
So one of the things I tell my clients when we get into litigation, one of my first questions I ask them is, who does your e-discovery work for you, right? Who does the ESI and the document review portion of that collection, production, and the like? It's still amazing that a good number of them still use the law firms to do that, right? And that's one of the first things I tell them, and sorry to the firms here, but is don't use the law firms to do that work, for at least for the first level doc review and the e-discovery work, because it's just too expensive. The vendors, a lot of vendors out there that can do this a lot more efficiently than the law firms. And the law firms sometimes will bring in their own outside vendors, but there's still a lot of firms that have their own in-house e-discovery departments. And using, associates to do, doc review, first level doc review for just responsiveness and privilege logs at $300, $400 an hour for an associate, is just burning money, right? So one of the first things I say is get a third party, either depending on the size, the amount of e-discovery you do, start off getting a third party vendor to help you do the collection, production, ESI, and initial doc review, and then have the law firms do the secondary doc review, right, after you go through the first level doc. The larger companies that tend to have a lot of e-discovery will then try and pull that in-house, right? And they'll get their own instances of relativity or whatever they're using, and they'll start doing the collection production themselves and do that. And then they'll probably still sub out the first level doc review to a vendor that does that, either in the US or offshore, But the going rates right now for doc review is, $40 to $50 an hour in the US, and less if you go outside. So, but not $300-$400 an hour, which is what you're going to pay at a law firm.
For someone who is in-house in a corporation, in the legal department, or in some fashion involved in the decisions about who they're going to pay and how much and under what terms, and they want to start taking advantage of the opportunities potentially offered by value-based billing, how do they get started?
Well, they have to start thinking in a different mindset, right? You have to get away from the hours billing, right? And thinking, instead of paying, dollars per hour, dollars per document, dollars per contract, dollars per deposition, like we talked about, where there's actual deliverable involved, and you're trying to tie the price to some sort of deliverable other than hours. And so you have to get out of the hours mindset, which is hard for lawyers, right? Because that's all they've ever done. That's the first thing to start thinking about, and then start looking at different, the easiest place to start is start with a smaller group where it's more repetitive type work, right? Contract work is an easy one to start with. Obviously, if you're not doing patent prosecution if you're still doing that on hours, real estate leases, if you do a lot of those types of contracts or whatever, immigration work, those are all ones that lend themselves to just fixed fee per type pricing. And that's a good place to start, and to just think about and go out and bid this out to different firms and say, hey, for an H-1B visa, give me a fixed fee, right, to do one. And go to several firms and select a firm based both on price and on the value that the firm brings to the table, right? So I think that's a good place to start, is just to think about lower level commodity work that's more repetitive. Subpoenas is another one. If you're doing a lot of third party subpoenas, think about a fixed fee per subpoena, right? And yes, some of the subpoenas might take longer than others, but if you're doing 30 or 40 a month, right, as some of my clients do, that comes out in the wash, right? So you can bid it out to the firms and say, give me a fixed fee per subpoena, right? So there's things like that. And that's where I'd start before you get into the more complex things like transactions and litigation.
Well, Ken, this has been, for me, enlightening and illuminating. Thank you for joining us. Ken Callander is the founder of Value Strategies. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Ken, thanks so much again.
Thank you, George, for having me today.